Hi, and welcome to HCCLA's Reasonable Doubt. Today we have a very special guest, Representative Jean Wu, and an also friend of mine. Today we're here to talk a little bit about law and politics. Jimmy?
Thank you, Julio. Good evening, everyone. Welcome to HCCLA's Reasonable Doubt. As Julio said, we're very blessed to have the Honorable Jean Wu, State Representative for the 137th District. Tonight we're going to be talking about politics and the criminal justice system here in Texas. And I'm here as always with my co-host, Damon Parrish. We're going to be taking your tweets, your questions via Twitter, also via Facebook. And we're going to start calls at around 8:30. We'll be taking them at 713-807-1794. So about 8:30 tonight, start calling us. And as always, you can send your tweets anytime. And then we'll start answering them around 8:30. I want to bring in my host, Damon Parrish. Damon, how are you this evening?
I am cold.
You're cold?
Cold. You know, it's unusual cold for Houston.
I think it's called a polar vortex or something, right?
It's some kind of a vortex, and I don't like it. It's cold.
It is a bit chilly in the air. Damon, before we get to our guest this evening, I want to talk about a few things that happened this week. I guess the big news coming out of D.C., our president nominated a replacement for outgoing Attorney General Eric Holder, and he chose Loretta Lynch, the U.S. Attorney for the Eastern District of New York. What can you tell our viewers about Miss Lynch?
Well, not much. You know, she's from the Eastern District, like you said. What I can anticipate, she won't do too much. I mean, only have 2 years left in the appointment of Attorney General's office, but she's there. She's going to continue forth with, I imagine, the policies of Eric Holder. So I imagine the feds will no longer, still not prosecute marijuana charges in those states that have allowed it. I don't imagine her to do much in office while she's there. I'm not for sure what she can do the next 2 years. I don't imagine much from her.
Do you think she'll continue with what Attorney General Holder has done in terms of the sentencing reforms, or is that something that's just going to maybe die on the vine with him? What's your take on that?
I believe she will continue it. I mean, I believe she will. Like I said, I can't imagine she can come with any fresh ideas with 2 years left on the tenure. But if she does, it will be perfunctory. I don't think she will be successful in it, but I think she will continue it, yes.
I guess the notable thing, Damon, she is the first African-American female to be nominated for the position. The Democrats obviously took a beating in the election last week. What impact do you think those two factors may have on her confirmation hearing?
I believe she will be confirmed. And I believe it's a step forward for women, for minorities. It's a good push for the Democratic Party themselves to say, hey, we have put somebody in this candidacy or in this position that is a minority, and it will help carry voters for the 2016 election. I don't think she'll have a problem with being confirmed. I really don't.
Turning to some local news, I guess this week one of the big issues that came out was at Beller High School, there was an alleged sexual assault that was of a student that was reported to police back in October, but apparently it wasn't shared with parents of the school until this week. What can you tell our viewers about that?
Just like you said, there was an alleged sexual assault, and I believe the rationale for it was that they're still under investigation and they didn't want to put anything out there to shame anybody. But what I would say is for adults that may be okay, but for juveniles, for children, something should be put out there. However, nothing was put forth. Assault took place, and I believe it allegedly involved multiple people, multiple parties. And they continued to go to school. They were students, continued to go there and be around this victim. So we're still kind of looking to see what happens there. But that's pretty much what happened, at least from the start.
Well, I think most of the complaint, as far as I'm understanding, is that the parents are a little up in arms that they weren't notified sooner. I mean, as you talk about, there's some, I guess, lack of a better term, desire to keep the potential victims and the potential accused secret for now. But don't you think the parents should have had a right to know this a little sooner than a month after the alleged allegation?
You know, Jimmy, that's a tough one. Without knowing the full facts of the sexual assault that took place, was it violent? We know there are multiple parties. We know that. But was it violent? What were the factors of it? It's kind of hard to say should have been notified because you are still dealing with juveniles. And even for juveniles that are we would say defendants or under investigation for a crime, they still deserve a little more anonymity or secrecy or protection than, let's say, an adult or a teacher would. So you have to balance the protection of all the juveniles involved versus disclosing, because once you put it out there, then there is no secrecy. You can tell parents, hey, we're telling you this, but keep it quiet. But once you put it out there, it's there. So it's kind of hard to say. It's hard to blame the school on that. But what I believe is, if it comes out that this was, in which it kind of sounds like it is, like a gang rape situation or some sort of violent situation, then I believe that should be notified, because the violence of this alleged sexual assault itself kind of mandates that parents be notified that there are some violent sexual offenders potentially in the school, and we need to protect our other children from them.
The final current event I want to talk to you about this evening, Damon, is we've seen this year, we've seen the Ray Rice incident in the NFL, we've seen the Adrian Peterson incident in the NFL, we've seen several domestic violence allegations coming out of the league this year. Notably, Ray McDonald, defensive tackle for the 49ers, the Santa Clara County District Attorney's Office declined to take any charges on the alleged domestic violence case against Mr. McDonald. What do you know about that?
Well, and it's interesting. What they did was they looked at the case and said, you know what? We don't think we can prove beyond a reasonable doubt that a sexual assault has taken, a domestic violence assault has taken place, and so therefore we will not pursue the charges. And I think that is very admirable and commendable for the District Attorney's Office in San Francisco, especially in light of the current policy in the NFL, what's been going on with domestic violence and the things that are happening there, to have them say, and by the way, they did a 10-week investigation. So it wasn't like they just talked to one party or two party and washed their hands of it. They actually investigated and said, you know what, maybe something happened, maybe they didn't. It might be more than probable cause, but it is not reasonable doubt. And that is the model that every district attorney's office, every county should follow in this country. If the case can't be proved beyond a reasonable doubt, even if you think they did it, you shouldn't prosecute it.
Fascinating stuff. As always, we're going to look each week at our current events and talk about the most interesting things that we think is going on. Please, as always, send us your questions, and you can even send us current events that you want us to talk about to @HCCLA_TV on Twitter. You can also like us on Facebook, HCCLA Reasonable Doubt. And tonight we'll take your phone calls at 713-807-1794. Pretty much anything you want to talk about is on the table this evening, ladies and gentlemen. I want to bring in our guest this evening, Texas State Representative of the 137th District, Mr. Gene Wu. Gene, how are you this evening?
How are you? Thanks for having me here.
Great. We're really glad to have you here. Now, Gene, you have kind of three focuses in your that you've been since you've taken over office. You look at energy, education, and criminal justice.
Right.
And for the purposes of our show, obviously we want to focus on criminal justice this evening. So you were a former prosecutor with the Harris County District Attorney's Office.
Right.
Kind of tell our viewers what you did and how long you were with the Harris County District Attorney.
I think I started back in like July of '09. I was there for about three and a half years. Started as a baby prosecutor in misdemeanor, did my rounds in misdemeanor, in JP court, in juvenile, then moved into felony. Just a normal prosecutorial progression. And then I ran for office, got elected, and because of state law, I have to resign. You can't both be a state employee and a state official at the same time.
Now, did you always want to get into politics, or was it just something that kind of happened?
No,
way?
I think this has sort of been in my blood for a while. I have a master's in public policy from the LPJ school at UT, and I've always had this love of public policy, and I think law is just the other half of the coin. One side is how do you make the laws, and the other side is how do you enforce the laws. I've done the enforcement side, and when the opportunity came up, and in fact I took over this position from your guest from last week.
Yes, you did.
And you know, and it was quite an honor to have not taken the seat, but followed in the footsteps of Scott Hochberg.
Now, you represent the southwest part of Houston.
That's right.
For our viewers, what area do you cover?
It's the main part of the district is really like Sharpstown, Gulfton, a sliver of Leaf, Briar Meadow, Tanglewild, and just essentially everything. The easy way to describe it is everything south of Westheimer and west of Chimney Rock up to the Beltway. And it's not quite exactly like that, but the district is shaped right now, currently shaped like a big cleaver. So it's got a big square section and a kind of long handle goes out to the west. So it's a little hard to describe, but it's roughly in the southwest area. You know, I have Chinatown in there. I have the Hillcroft-Harwin district. I have the El Salvadorian area. I have the Guatemalan area. It's probably the single most diverse district in the entire state. And it's largely, a good chunk of it is immigrants, and probably the best food in Houston.
Now, you said you had to resign your position with the Harris County District Attorney's Office. Does the state rep job pay full-time wages?
Well, it's a matter of public record. So state reps and senators both make $600 a month before taxes, and after taxes, after insurance, it doesn't quite cover gas. So
what do you do to make
the answer to that is?
Well, what do you do to make up the difference? Because obviously it's going to be pretty tough to live on $600 a month.
No, I'm actually I'm out in private practice right now. I handle criminal cases, I handle juvenile cases, I handle CPS appointments, and I do civil work as well. So you got to do what you got to do, right?
So you're really in the front lines every day.
Absolutely.
Yeah.
Do you have a question for you?
Yeah.
Given that you were a prosecutor, and now you are, and that was enforcement side of the law, and now you're on a politician making the law, which one do you find, which one was harder? Which one was harder for you to do? Which job did you find it more difficult to deal with the day-to-day, and which one do you find more rewarding?
Being a state rep is something that I've always wanted to do, and make no mistake about that. But, you know, I loved being a prosecutor. That's one of those jobs that I woke up every single day looking forward to going to work. I felt good about what I did. I felt like I could do the right thing for, you know, pretty much everybody I met that day. And I went to bed, even losing trials, I went to bed sleeping, you know what, that was the right outcome. I should have lost that trial because I didn't have the evidence to prove it, and I should lose if I didn't have the evidence to prove it. And I look forward to going to work, and it was a job. It was one of the toughest jobs I've ever done. I know, especially for the prosecutors during the during the recession, when we had a hiring freeze, we were way overworked. Our caseloads went through the roof, but I still loved it. I'd always tell people the joke is, you know, long hours, low pay. What else could you ask for? You know, but it was still. It was personally very rewarding for me. That's not to say I don't love being a state rep. I love being a state rep. I love being in policy. I love being in politics. But man, I loved being a prosecutor.
That's fair.
Gene, how many of your fellow legislators have experience in the criminal justice system?
Out of 150 members in the House and 30 members of the Senate, one senator, Joan Huffman, is a former prosecutor. She was a district court chief, and then she was the district court judge. She's the only one in the Senate that has actual criminal justice experience. And that's not to say that there's not other experts. Senator John Whitmire is not only a champion for criminal justice issues, but you know, is very clearly an expert. He knows what he's talking about. And on the House side, I would say there's maybe 5, maybe 6 members out of the 150 who actually practice, in either have practiced or are currently practicing in the criminal justice realm. It's not a lot.
But how often do criminal justice issues come up? How many people are putting forth bills or trying to get studies put forward on criminal justice? How many people are trying to do that, and how often does it occur?
That's actually the sort of the interesting contrast, in that even though there's not that many people who have actual experience in the system, virtually every member, almost to a rule, almost every member is going to file some type of criminal justice bill almost every session. or they will file some at some point in their career. The Criminal Justice Committee is probably one of the busiest committees in the House. Their committee hearings later on in the session easily go into 5 o'clock in the morning.
And I think I read something that 25 to 30 new criminal laws are passed in Texas
Right.
every year.
The average for Texas is about 25 to 30 new criminal violations are created by law by the legislature every session. And that's something I think is very disturbing. I think that's something that basically needs to stop. I think we're over-criminalizing too many different things. And the problem is, everything under the sun that I think most people would say should be criminal has already been criminalized. It's wrong to steal. There's a law against that. But the problem is we create new redundant laws to say, like, well, and I'm just making this up, it's wrong to steal shellfish. Like, you can't steal oysters. Well, it's already wrong to steal. Why do you specifically need to make it illegal to steal oysters? But the problem is...
Is that born out of some special interest or constituency issue?
Yeah, and...
What's the root of that?
Usually what happens is that every state rep has their own constituency. They have their district, and they have people who care about certain issues, and you have their local law enforcement. So, you know, my district is solely within Houston, and HPD and Sheriff's Office, and maybe the constables are my main constituents for in terms of law enforcement. But if you're out in West Texas, your district may cover 40 counties or 30 counties, and you're dealing with dozens, if not hundreds, of local law enforcement agencies, and they're going to have some independent issues. Well, we're always having problems with this thing, and can you please pass a bill to take care of it? And so, or you might have constituents that say, well, I really hate it when this happens. So they said, would you please pass this bill? And, you know, all politics is local. And so eventually you as the local official have to deal with that, and you have to address it somehow. Even most people tell you, like, hey, it's not really a big deal, like, it's already covered. But if your constituent really wants it, you got to try and push that through, because otherwise you're going to have a very mad constituent back home.
So, Gene, do you find it difficult then, given your extensive background in criminal justice issues, being a prosecutor for 3.5 years and now being in the legislative committee, do you find it difficult having to navigate those issues, given your experience, given your knowledge, and your practice in criminal justice prior to being a state representative?
I think it's easier for me to navigate the issues because I actually, you know, I have experience in what I'm talking about. When I talk to people about their bills or talk to people about my bills, I can tell them, look, this is what it actually does, and this is how it's going to work, and I can answer people's questions. And that's actually been a strong point for our office, because even as a freshman, you know, we're sort of like, you know, punching a little bit above our weight class, that we're able to help more senior members with their legislation, because everyone files criminal justice bills, but they may not understand the intricacies or the details of how it functions in real life, or how it actually would work in court. So we're always able to lend a hand with that. But one of the areas where it is a little more difficult is a lot of times I have to bite my tongue for political reasons about, you know, about bills. So like I said, everyone carries bills, and some of them are better than others. And sometimes I have to sort of, like, you know, for political reasons, just like, you know, I'm not going to keep my mouth shut about it. You know, I'm not really a huge fan of it, but it doesn't really hurt anything. But this is somebody who's important, who's carrying it. I'm not going to go offend them and then, you know, damage my relationship with them.
So were you surprised by the amount of politics involved in the criminal justice system prior to being in the political arena, or were this not surprising to you at all? Were you just always aware of it?
I don't think there's very much politics in the criminal justice system itself, in that the judges that we have are very fair. They take their jobs very seriously, and they do a very good job of being unbiased and taking their and just doing what they're supposed to be doing. The legislative process, no, I'm not really surprised. I mean, politics is how it works. It's how, you know, human beings have gotten along for thousands and thousands of years.
How much actual debate do you guys get to have about the criminal issues when they come up? I mean, somebody proposes a bill. Is there any real debate in Austin over this stuff?
It's actually kind of interesting. It's sort of a yes and no, in that when we do have debates, we have very vigorous and passionate debates about the larger issues, whether or not there should be a death penalty, whether or not this thing should be a crime or not. But the things that actually I think matter more to people who practice, to judges, to prosecutors, to defense attorneys, are the little nitpicky, intricate procedural issues of, what do I have to turn over? Or what happens if my guy goes to prison for X number of years? What happens then? What does the prosecution have to share before a trial? Those things, I think, are in a sense more important, but they don't really get talked about because most people just don't know. They don't have any basis to talk about it, and so the conversation on those aspects are very limited.
Well, one of the big issues that's been debated around the country is obviously the legalization of marijuana.
Sure.
Oregon became the third state last week to legalize marijuana.
And didn't D.C. become the fourth, or are they still working? D.C. passed as well.
D.C. just passed it.
Did they?
Yeah.
Okay.
I know it was waiting on the legislative to prove it, but D.C. passed as well.
So now we got four jurisdictions in the country that have legalized marijuana. And I know you have or plan to propose in the coming session a split. I mean, do you think that legalization is a viable possibility in Texas, or what about this? What about this split that you're going to propose?
Well, from my estimation, from my analysis, from my gut check of this, I don't think legalization is going to be possible in Texas. I don't think politically decriminalization is even really possible in Texas.
And what is the difference between decriminalization of marijuana and legalization of marijuana?
I think I don't know how to really answer that for you. I think to me they're kind of the same thing. I think people have their own rationalization of how they're different. I mean, legalization is just, well, it's completely legal. Decriminalization is, I think you just basically...
You just don't enforce it.
Just not enforced.
Yeah,
you get a slap on the wrist or something like that.
Okay.
I don't think that's possible in Texas, in our political climate. Don't forget, Texas is still the reddest of the red states, and the conservatives are very conservative. And they don't see marijuana as, and a lot of people who oppose it don't see marijuana as a problem for them, for their community. So they're like, we don't want to deal with it. But what we propose is this. The bill that we're going to propose is going to take Class B marijuana, which is currently between zero, essentially what is zero, or quote-unquote usable quantity, up to 2 ounces. So, and there's like 28.53 grams in an ounce, right? So let's call it 30. So that's like between essentially 0 and 60 grams. And a gram is about a sugar packet, okay? So what we propose to do is this. Take Class B marijuana and take everything below 10 grams and push it down to a C.
Which means writing a ticket.
Which is basically a ticket. So a Class C is written in the law that Class C violations, you do not have to arrest someone. Okay, there's only 2 offenses in the state law that are non-arrestable: is speeding and open container. You go figure that one out. But all the offenses, like regular, like running a stoplight, not having a seatbelt, those are arrestable offenses that you don't have to. Okay, and what we're trying to do is make it so that officers don't have to arrest someone. They can give them a ticket they want, but they can also arrest them if they want. That way, I think if we, and again, 10 grams, it sounds like a lot, but it's really not that much. In fact, I would say like 95% of the cases in misdemeanor court in Harris County that when I was a prosecutor there were well under 10 grams. Most cases, we're talking about like a gram. Most people that get busted with a half a joint, with a joint. I've had people busted for having seeds. And fractions of a gram. Like you take a sugar packet, you cut it down to, cut it into 20 parts, and somebody got busted with 1/20th of a sugar packet. marijuana. And the problem is not that they got busted. Okay, they broke the law. They're wrong. Okay, the problem is that we as taxpayers have to deal with that. So,
talk about that for a moment. What's the actual costs that we're looking at under this?
So, and here the thing is, my bill is actually brought forth to me by law enforcement. It's the people who asked me to carry this are my friends in the prosecutor's office who have to deal with this. And I'm not going to name their names, but because I don't get them in trouble. But the thing is, there is a serious cost in law enforcement. So you talk about someone, let's say like you have a 17-year-old who's busted, gets pulled over, he has like a half a joint in his ashtray in his car, okay? And it's like a fraction, like a half of a gram. So that officer has to arrest them. And they get pulled over. So that officer has to arrest him, has to cuff him, has to search his car, has to call out a tow truck, has to get the car towed, has to take the kid to the station, gets booked in, gets a quick inventory, and then officer has to transfer him to Central, then he gets booked in again, he has to search him again, and then Central Jail has to take him in, strip him, search him, run him through medical, run him through psychological, run him through gang affiliations, run him through whatever else they need to do. Give him a bed, give him some clothes, feed him, and I think on average you're looking at about $50 to $75 a day, and that's not including intake and all this other stuff. And so you have an officer who's basically now out 3, maybe 4 hours to do all the processing, write his report, have a coffee break, finish writing the report, have another coffee break. So, and then you have the jail who's doing, so you rack it up, you're looking at about $1,000 a week, or $1,000 for each prosecution. And, talking to the sheriff's department, just to eyeball it, they're estimating that if we can get rid of these prosecutions or move it down to a Class C, Harris County could save $100,000 a week.
And that's just the Harris County Sheriff's Office. We're not talking about HPD. We're not talking about the other municipalities.
Just the jail. Just the jail.
Just the Harris County Jail alone could save $100,000 a week.
Right.
So how do you contrast that with, let's say, making a Class B just all instead of splitting it? Why not just make the entire Class B? Why limit at 10? Even though 10 grams is what 99% of it is, why not make it a full 100% and say if it's under 2 ounces, boom, let it go?
Partly because of political reasons.
Right.
Partly because if you move Class B down, then you'll have to move Class A down. Then you have to move state jail down, and then you have to move second degree down, and move first degree down, and then that's much a harder political proposition to sell, and it's a bigger change in the code. If you just split Class B and to cover 95% of the people, that takes care of 95% of the problem of people being prosecuted for and taking convictions on relatively minor crimes and basically just ruin their life over half a joint.
So as a prosecutor, you know that if you're convicted of a drug offense in Texas, your license is suspended.
Yep.
You know that.
Yep.
All right. Under your split plan, if you have the under 10 grams and you're now to Class C, does your plan cover the effects it might have on a license? Are you still suspended, or will there be some sort of allowance or provision dealing with the license?
Yeah. Well, hopefully, as a Class C, most people would take a deferred adjudication. For most JP courts, you don't do deferred adjudication. You do deferred disposition.
Right.
So basically, you do your probation, and then if the case is dismissed before it even goes to the adjudication process. So ideally, most people would just, they get caught, they get busted, they have to go to court, they do community service, they pay some fines, they make some donations, and they don't get caught for like 6 months, 3 months, whatever it is, and they don't do it again, and it's off their record. So hopefully they won't do it. If someone takes a conviction class in misdemeanor crime, I really don't want them to have their license suspended. I don't have that in my bill, and I wouldn't be for it because I think as a prosecutor, I think too many people have their license suspended, and I think it makes them more likely to commit another crime. Mm-hmm. Because as a prosecutor, I handled just thousands of people with DWLIs, or driving while license invalid, and these are people being busted driving to work.
Right.
And I think it's unnecessary. I think it's too much. In Texas, we don't have a solid public transportation system. That's not my opinion. I think everyone would pretty much agree. You really can't get around Texas. You can't get around Houston without a car. It's hard. It's really hard unless you just happen to live off of the bus lane or something. So suspending people's licenses for every little thing, I don't think is good. I think it's, you know, if people are working, let them work. We want them working instead of not working.
Right.
I want to remind everybody to send in your questions to @HCCLA_TV on Twitter. And also, we've opened up the phone lines now, so give us a call at 713-807-1794. And I believe we have a caller right now on the line. Hello?
This is a good show tonight.
Thank you.
All right. That's what we strive for.
About marijuana, legalize it yesterday, please. No, you can't go to your doctor and get a Vicodin anymore unless you got a sack of money. There's only 6,000 providers that can do that in the country anymore, down from 1.5 million. So, yeah, legalize it, please. And let's do it then different from other states. Bring in the cartels because they're the only ones that can do it cheaply. They've been doing it for years, and they're probably masters at it, just like a wine grower, for instance. So, also, one more question for
Yes.
the representative. Any comment about the HPD Super PAC contributions to legislatures, especially in the big election year in 2016? I'll hang up.
Thank you. Thank you for your question. Gene, I don't know if there's anything you can comment about the Super PAC.
Just be full disclosure, I mean, HPD has endorsed me in this election and past elections. I was just reelected just this election cycle, and the HPD's PAC has given me money. You know, the HPD Police Union wants to be a part of the political process, and I think as everyone else should want to be part of the political process. They gave me money as they gave a lot of other legislators money. You know, I think that's a good thing. I think they want to be a part of the process. I don't see any problem with that.
Now, I know you, I think you said you had a funny story about a marijuana story that you wanted to share with our viewers tonight.
All right. So you're aware that that Harris County is actually the only county, I believe, in the nation that has what we call a police desk, where police have to call in and ask for charges, and the charges have to be approved by the DA on duty, and we call it intake. So, and I loved working intake because it was just interesting to do because the best stuff happens, you know, between midnight and 5 a.m. So I loved working late night intake, and when police officers call in, you generally can have a feel of whether they want you to take charges or not, because sometimes the officers use you to get rid of charges they don't want, they'll usually sell it that way. And I get this officer call in, and you know, I'm working a misdemeanor desk, so it's nothing life-threatening or really all that huge. And he said, well, I have a marijuana case. And I'm saying, well, let me hear it. Let me run through the situation. Let me make sure you have a good stop, a good search, and a good arrest. And he's selling it to me. I'm like, well, it sounds like you're trying to get me to get rid of this thing. Well, tell me really, be more detailed. Tell me how this happened. And he runs it down for me. And he says, well, you know, I saw a tow truck pull on the side of the road with this car. And apparently, you know, this kid was going on his way to college, on his way to class, and had broken down. And so I said, you know, like, hey, I want to make sure these guys are okay. I'm going to pull over and stop and put my lights on so people to go around them. And you know, I want to make sure they're good. And so the officer walks up to the kid and he goes, hey, you know, your car's busted. I know you said you're going to class. Can you want me to help you get you to class? And he goes, yeah, sure, that'll be great. And so like, well, let me get my books out of my car. So the officer says, yeah, go ahead and give it to me. And so the kid hands over his backpack. You know, the officer takes it. Hands over his lunch sack. The officer take it. You know, kid hands over his bag of weed. The officer take it. And the kid, so the officer is just something like, look, the kid's just dumb. I mean, I didn't even have to stop here. There's no reason for me to be here. I just want to make sure he was okay, and he's just going to class. Like, I don't really want to arrest him. And I was like, oh, sorry, man. You know, law's a law.
Called it in. You got to take the charge.
Yeah.
Gene, we have a couple questions coming in on Twitter. One of them kind of harkens back to your days as a prosecutor. One of our viewers wants to know, do you think that the current true habitual enhancement statutes need reform? Do they give prosecutors too much leverage, and are they part of the prison overcrowding problem in Texas?
Yes and no. I'm sure you'll hate that answer. So this is what I think.
The answer of a politician.
The answer of a true politician. So I think for the true habitual enhancements, if the persons are truly a violent criminal, or they're just, they like robbing people and they like, assaulting people, that's one thing. The problem is we use it a lot on drug offenses. And here's the thing. When I was a prosecutor, I have sentenced people to 25 years for drug offenses.
And that's a mandatory minimum.
And that's a mandatory minimum. And I don't want to say I'm proud of that. I didn't feel good about it, but that's what the law was.
Now let's break that down a little bit, because I guess for our viewers, an enhancement is something that when you have a previous conviction,
right,
allows them to raise the mandatory minimum punishment for which you could be charged and convicted of.
So let me help you explain just a little bit. If you have like a little bit of crack, you have like between a gram and less than a gram to like down to molecules. That's a state jail felony. Anything more than a gram, 1 to 4 grams is a third degree, and above that is a second, first, and whatever else. Most people that get busted with a state jail felony amount, like a tiny about a couple of rocks, or a third degree amount. Problem is, if you've already been convicted of a third degree felony for having crack, well, your next third degree is now bumped up to a second degree. And then if you have 2 prior convictions for having crack at the third degree, then your third one's going to be now a first degree. You're looking at 25 to life, a minimum of 25 years to life for having crack. And I know, crack is a bad drug. You shouldn't have it. It should be illegal. But we're sending people to prison for 25 years at $35,000 a year for a substance abuse problem. They're not selling, because selling is actually a higher offense level. They're using. And, we're treating a mental health and a health issue by putting people in prison. I think it's not good. It's not justice.
Well,
and it's not good for our society.
With the enhancements, there is some amount of allowances you had as a prosecutor with dealing with those, correct? So,
right.
You can strike the enhancement. You
Absolutely.
You can plead as charged without the enhancement, whatever. What rationale goes into saying, okay, for this case, and it will stay state jail even though it's enhanced, and for this one, you know what, it's 25 to life, it's going to stay that way. What rationale happens when you have to deal with that?
I think, as in my experience, prosecutors often used, most prosecutors, the vast majority of prosecutors have very good judgment. They want to do what is right, and they see the inherent injustice of sending somebody to prison just for crack for 25 years, for 2.5 decades. And they will do the right thing. But a lot of times what they do is they use, what I did was I used the enhancement as a bargaining lever.
Right.
Like, look, you can either plead to it, or I keep the enhancements on and you risk doing, 2.5 done, doing 25 to life. What my concern is that it is inconsistent, that what you get from one prosecutor could be vastly different from another prosecutor. And I think that's not just. That one person may end up doing 25 years or more for having crack rocks, for having a substance abuse problem, versus just waiting 2 months and then you switch prosecutors. So,
or it can even vary from a county to county.
Or vary a lot from county to county. I know some of the smaller counties, the real tough on crime counties, are, they never abandon enhancements.
And they can be especially tough on people coming through who are not from that county. If you're passing through and you get caught with drugs, they have no mercy on you.
Right. And so I think one of the problems is because our prison system is paid by the state, they don't see it as, I think, and I'm maybe overgeneralizing a little bit, is I think some of the smaller counties say, like, well, once they're once they're in prison, they're not our problem anymore. They're the state's problem. So this is our way of just getting rid of them.
Gene, we actually have another question for you, and it is whether the driver responsibility program dealing with surcharges, I guess DWIs, that kind of stuff, should be repealed. So first, what's your thought on that program, and do you think it should be repealed, the state is, modified, changed, or what?
I don't think that the driver responsibility program as it is does anything for us. It doesn't make us safer. It doesn't punish criminals, punish people who are convicted of DWIs any more than they already have. I think it makes people more likely for recidivism. Right. I think because you tell people you have the choice of either not driving and not working, or drive and break the law. Most people that I know say, if they have a family to feed, if they have to take care of themselves, and they're responsible people, say, look, I got to work. I got to put bread on the table. I got to keep a roof over our heads. I'm going to work. I'm going to risk picking up a ticket. I'm going to risk getting arrested. That is a horrible choice to force people to. When in fact, if people are on probation, people have been convicted of a crime, and you want them to do right, you want them to work. Mm-hmm. You need them to have a job, and you need them to have transportation to a job. I am in favor of undoing the current driver responsibility program. I think you should fine people. I think you should make them do community service. I think you make them do a whole bunch of things. I think you can make them put a breathalyzer on their car. But I think simply taking away their car as a default punishment is not just, and it doesn't make any sense from a public policy perspective.
Or at least not for your first time DWI.
Right.
Maybe for your second.
I think if you're a habitual,
that's different.
I think if you're going to get into your second or your third DWI and you have shown you can't drive responsibly, I think taking away your car is the right thing to do. Here's the problem. People who are not drinking responsibly, they're going to drive. You know, just saying that you're not supposed to drive anymore, they're not going to stop driving.
Right.
So.
We have another call coming in. Let's go to the phone lines. Caller, hi. How are you doing?
Hi, Jimmy. Hi, Damon.
How's it going?
Long-time watcher, first-time caller. Thanks for the call.
Great to hear from you.
I want to go back to something that the representative said a few minutes ago. Representative Wu, you mentioned that when you were a prosecutor, you used enhancement statutes as a way to get leverage over people when you were already willing to abandon the enhancement. My question is, do you as a public servant, as a public official, as a moral and ethical person, do you think that's fair? I'm not asking what you think about enforcing the law as it existed, but do you think that's fair? And I'll take the answer off the air. Thanks.
Thank you.
Thank you.
So,
and there's been great debate about it nationwide.
I thought it was fair when I did it. I think it's even as a defense attorney now, when I'm presented with the same options, I think it's fair because that's what happened. If you are enhanced with those prior convictions, you got those convictions. You are a 2-peat or 3-peat felon. The reality of it is, I think your question is more of, is it just? Is it just that someone gets convicted when a prosecutor was willing to abandon enhancements? That's a little harder question to ask. I'm not sure I can always answer that very well. You know, everything is on a case-by-case basis. You know, sometimes when I can only speak for myself, I can only speak for what I've done. If I had someone who was, all they had were just drug convictions, and that's it. You know, I felt it was unjust, and I frequently abandoned those enhancements. If somebody was convicted of prior, with a prior rape and then a prior aggravated assault and a prior burglary of a habitation, I'm like, you know, I don't feel bad about that. And you deserve to go to prison for 25 years minimum because, you know, you're a bad guy.
Well, Gene, I want to move to one of the other topics that I think is near and dear to a lot of criminal defense lawyers' hearts. But I also know it's something that you're looking at in the legislature, and that is the push to bring back deferred adjudication on DWI cases. The legislature did away with those in the mid-'80s, and you could no longer get deferred adjudication. And for our viewers, deferred adjudication is a form of probation that if you successfully complete it, you don't have a conviction on your record. Currently, as it stands, in the state of Texas, if you get convicted of DWI, you cannot get it off your record.
Right. So the move to get rid of deferred adjudications was a well-intentioned effort with unintended consequences. So back in, I think, the 1980s, MAD, Mothers Against Drunk Driving, pushed this throughout the country to remove deferred adjudication as an option for DWIs. And with the intent that of making DWIs a more serious crime, therefore fewer people would do it. Problem is, it actually had the opposite effect. Because what happened is, if presented with the possibility that you can either do probation or take a straight conviction, which is the same thing, you're convicted in both. People said, well, let me just take a straight convictions. Let me just do a little jail time. And a lot of judges a lot of prosecutors and throughout the state said, like, well, it's your first DWI, we're just going to time serve you. You spent like a day in jail, 2 days in jail, we'll call it even, right? So what the practical effect of it was that people just spent like a day in jail and said, hey, that wasn't that big of a deal. Let's do it again. So recidivism rate for DWIs actually started going up as soon as that law was changed. It started going up. So the idea of undoing this, to put deferred adjudication back on the table, is to get people into probation, where we can put an interlock on their car, make them blow into a breath test machine every time they drive, to put them on probation, make them do counseling, make them do community service, make them go to Alcoholics Anonymous, make them get the treatment that they need so that they will not reoffend, and to constantly remind them of the seriousness of what they did, instead of just going, get out of here.
And I think a lot of district attorneys have realized that. Like, for instance, in Harris County, they have a form of pretrial diversion. I know in some of the other major counties, they have forms of pretrial diversion where you actually enter a guilty plea that if you violate the terms of the pretrial diversion, that guilty plea is then entered against you.
Right.
And you then can't come back and challenge that. But what's the biggest obstacle to getting deferred adjudication back on the books?
Right. I think deferred adjudication has been discussed, and the bills have been filed for past, I think, want to say about 2 or 3 sessions. What it really comes in the beginning, what it was like, people, well, we don't want to do it because we don't want to be soft on crime, we don't want to be soft on DWIs. But now people understand what the issues are. People are ready to move on it. People care about it, and they understand the ramifications of not doing it. Right now, it's more or less a political impasse, as far as I understand. And again, I'm a freshman in the House. I'm not really privy to all the high-level discussions. But from what I understand, what's been relayed to me is it's more or less a political fight about what are the exact requirements of that deferred. And I think there is a pretty substantial fight about whether interlocks are either required or recommended, whether or not by law you have to have an interlock on your car versus whether a judge can order it. Now, most judges I know automatically order interlocks on all their probation, DWI probations. But
a lot of them even order it as condition of bond now.
Absolutely, and that's right. But the problem is, in the political world, people get into fights about interesting things, about small things, big things. Sometimes, it's just it's a battle of wills. Somebody says, well, I don't care if it's little. I'm going to do it until I get my way. It is what it is. But I think people need to tell the representatives, tell the senators. I think this is a good thing. It moves us forward. It reduces recidivism. And, it gets people back on the right track.
Do you think there will be a proposal in 2015 by you or by somebody else to get this back on the table?
I think our office may carry the bill. I believe there will be another sponsor in the House and the Senate. If nobody carries it, then we probably will. This is something we're very interested in. And again, the people who have asked me to carry this are not defense attorneys. These are people who have asked me to carry this are prosecutors. prosecutors like our hands are tied under the current system. We're in a damned if we do and damned if we don't type situation, and we want to have more options. We want to give judges more options. We want to give the prosecution more options.
There's another question that I want to get to on Twitter that came in. It talks about the Michael Morton Act, and the person wants to know if you were a supporter of the Michael Morton Act in its current form, or do you believe it needs any more revisions? And for those who don't know, the Michael Morton Act is the current legislation that allowed defense attorneys to basically get the entirety of the prosecutor's file, and there is no more hiding of evidence, and at least in theory that's what it's supposed to be, that we should get everything as defense lawyers that's contained within the prosecutor's file.
I think the biggest issue with the prosecution policies in the state in general before Michael Morton was the utter inconsistency around the state of what the policy is. Every single DA's office had a different policy about what was shared, what was not shared, and you move, to a new county next door, and the rules are totally different. Harris County has always had an open, for as long as I was there, had an open file policy of you want to come look at it. I always knew when we had brand new attorneys that would come on the scene because they well, I'm going to file this motion to get this and this and this. I'm like, dude, here's my file. You can go through it. Just don't read my work product. Or if you really, really want to read my work product, go for it. I don't care. There's nothing in there that you don't already know. But I supported the bill as is. I think, well, let me say this. I think I would have, coming straight from the DA's office, I think I would have liked, and I actually did ask for some provisions for the prosecution. I think there should have been a little more of an exchange. I think the defense should have a complete and open access to the prosecution file, with the exception to the confidential materials, like confidential informants and whatnot. But I think, I would have liked to have the prosecution given something in exchange, maybe like if you're going to plead self-defense, you need to give like a 2 days notice, so the prosecution can subpoena the right, proper witnesses, or something like that. But politically, that's not the way it worked out. So I think there will be some tweaks to it. I think there's some enforcement aspects of it that need to be tweaked. I think there's some disclosure aspects need to be more properly defined of what is kept by the police, what is not kept. So
when you say enforcement action needs to be tweaked, what by way of enforcement are you anticipating, or are you thinking is going to happen as far as this bill?
I can't tell you. I cannot tell you specifically anything right now. Yeah. And the reason is because I'm still meeting with law enforcement, and I'm still meeting with the criminal defense bar to talk about these issues. And this is what I want to do, and you're welcome to participate in the process.
Yeah, thank you.
Is I would like law enforcement and the defense bar to sort of like, hey, what do you guys want to see changed? And I don't want to make any changes unless we sort of have a consensus of, okay, either we do an exchange, like you get this and we get this instead, or like, no, we both think that this is something that needs to be tweaked just a little bit, like the language or the wording. I think some of the one area where I would like to probably make some changes is having how the judge makes a determination of what issue, like if something needs to be reviewed, of how it should be reviewed and how that process would work.
Well, let me ask you this: Do you, Gene? I know you've done criminal law as a DA. You've done it as a defense lawyer. You've done a little bit of civil law.
Done a little civil law.
And now you're a legislator. Do you find it ironic in some degree that as a civil litigant, not just in the state of Texas, but in this country, you have more discovery rights than you do as a criminal defendant?
I think, yeah. I think
you have more rights for discovery if money is at stake than you do if your life and liberty is at stake.
Yeah, I understand.
Is there something fundamentally wrong with that?
I think there is, and I'm not sure. I'm trying to think of a good response to that. So that's a very good question, actually. You got me a little bit. But I think the way that civil discovery works is vastly different. in a criminal trial, the defense's biggest weapon is trial by surprise. And I will say that as a now on the defense bar, I will say that the trial by surprise is wonderful. I hated it when I was a prosecutor, but you don't get to do that in a civil case. In a civil case, like if you're going to trial, you know everything that everyone's going to say. There will be no surprises. If you are surprised by something at trial in a civil case, you did not do your job as in discovery.
Right.
So I think the dynamics of a civil case and a criminal case are vastly different. I think, the state does hold all the cards. But when I was a prosecutor in Harris County, one of the things I was always taught was, look, you are the state. You are the white knight. You are the person on the white horse. That you should wield your power with ethics and with some humility. That if you have something that's bad in your file, then you need to think about dumping your case. If you have something that's wrong in your file and you can't prove beyond reasonable doubt, like you said earlier, if you don't believe it, get rid of it.
Right.
Okay. If you, as a prosecutor, have doubts about what happened, then why would you ever present this case to a jury or a grand jury? Get rid of it. Do your job. It's your ethical obligation. And if you have something that I think helps the defense, and it's bad for you, you need to tell somebody. It's your job. It's your ethical duty because you are the white knight.
And Gene, you mentioned this. You said that from the defense standpoint, the biggest strategy we have is trial by surprise.
Right.
Well, what about the idea that that's the only strategy we have? I mean, as the state has so much. I mean, you have the police force, you have the lab, you have so much going for you, and that as a defense side, and a lot of times we represent indigent persons who don't have anywhere close to the resources to defend themselves, and all we have.
Well, you have one more thing. You also have the only witness who actually knew what happened. Right.
All right. Well,
defense you have the only witness who was the eyewitness to everything and actually knows what happened.
Well, assuming your guy was there.
Assuming your guy was
assuming he was there, which if your guy wasn't there, if he didn't do it, and he's the kind of person.
From what I've been told, like back in the old days, if you asked for discovery in a criminal case, they would hand you the indictment, and that's it. Right. No police report, no forensics. It's like, well, you want to see it? You'll see it at trial.
Right.
I don't think criminal cases should be handled like that. I think when I was a prosecutor, I was like, I was always told, the more you're open with the defense bar, and more you tell them what's going on in your case, more likely the guy's going to plead out. More likely the guy's going to say, okay, if you're the criminal defense attorney, you see it's a DWI. They said well, you look drunk on the video, you had a bad breath test, you did all these things, you cussed the cop out. Like, dude, you're guilty. Your jury's gonna nail you. Just plead out.
Well, Gene, I think we're getting close to time here. Jimmy?
Yeah, Gene, we appreciate it. We appreciate your time this evening.
Appreciate it.
And I know we threw some hard questions at you, and our callers brought, and our Twitter people brought some really hard questions at you this evening, and you did an admirable job with it. And I thank everyone who joined us on the program this evening. For Damon Parrish and Jimmy Ardwan, I'm Jimmy Ardwan. We thank you. And we are going to have a show next week, so tune in, 8 o'clock Central Time. Like us on Facebook, follow us on Twitter, and we'll see you next week, ladies and gentlemen. Thank you.